Breaking news from Moscow, Idaho. Another document dump in the Idaho student murders case. This one, like so many others, it came as a bit of surprise. A lot of documents tonight. Quite a few. I got to shout out to my friend Anna, who always alerts me, my lawyer friend, when these documents come down and then helps me explain them to me, because this one tonight was quite complex. Bryan Kohberger's defense team now asking the judge to throw out Kohberger's indictment that was handed up in May by a grand jury. Kohberger's argument is the grand jury was misled as to the standard of proof needed to bring charges. Here to help us navigate this breaking news tonight, criminal defense attorney Mark Geragos. We couldn't have anyone better on than you, Mark. This is amazing to have you tonight. First of all, what does this mean? Bryan Kohberger's defense never wanted a grand jury involved in the first place. Now saying the grand jury process was done all wrong. Do they have a point here?
Yeah, well, yes. I didn't talk to you about it, but I talked to your better half, Ashleigh. The idea that they went to a grand jury, I think, took the defense by surprise. You'll remember all the skirmishing about one of the witnesses that was out of state that they wanted to have compelled to the preliminary hearing. And they ended up compromising on that and saying they do what was called a deposition in a criminal case, which is not common practice. Here, what they're saying is, look, we not only were not told or given enough advance notice of the fact that they're going to the grand jury, but the standard, meaning the instructions that were read to the grand jury, were wrong. And what do you mean by that? There are jury instructions that tell you what the standard of proof are or is. In a grand jury or a preliminary hearing, that is what's called a probable cause proceeding. That means, I sometimes joke, does that mean my client is breathing? But the legal definition is there a substantial amount of proof of the crime? Obviously there is, and that it ties to the defendant or the accused. Here they're saying that the standard as it was read to the grand jury, and mind you, they've got a court reporter in there that is transcribing everything, and they make the point that the grand jury was misled. Now, that would not necessarily throw out the case. What they're saying is, okay, the grand jury indictment is flawed. Now let's go back and have what we always bargained for, so to speak, which is a preliminary hearing where we get to cross-examine witnesses, something you don't get to do in a grand jury indictment.
So we thought there was going to be a preliminary hearing initially. Then there was the secret grand jury, and we found out no preliminary hearing. I mean, do you think there's a good chance we could end up actually having a preliminary hearing after all?
I'm always dubious or cynical about the idea of a judge throwing out a grand jury indictment. It's not commonplace, and especially in a high-profile case like this, but I've seen it happen. I can give you some high-profile examples of when it has happened. I think they do have, the defense has got a compelling point, meaning they said we were led to believe that they were going to do a preliminary hearing. Based on that, we waived our right to a speedy trial, aka preliminary hearing. We relied on it as a contract. Basically, when you waive your right to a speedy preliminary hearing, you're relying on the fact that you're going to get a preliminary hearing. To then have the prosecutor go behind your back, basically, do a secret grand jury indictment, that would mislead. And so if they can show that clearly there's a substantive difference in what the law was that was read to the grand jurors in secret, and they've got the transcript, then a judge has got a real problem. Does he want to force them to go to trial based on an infirm indictment, or is he better off just giving the defense what they want, or she giving what they want, a preliminary hearing?
What do you make of this defense team, Mark, based on the filings that you've read, from what you've seen? Obviously, you would know way more than me, but just as a non-lawyer, I mean, they seem pretty slick to me with a lot of these filings.
I always resent when somebody calls a defense lawyer slick.
Sorry.
I will tell you,
my dad's
yes.
a defense lawyer, by the way, so take it with love.
I know who your father is, so I don't take it personally.
Okay.
I'm just telling I think that this team is very skilled in capital defense. I mean, there are a lot of defense lawyers who are very good but never do a capital case. Capital cases require a constant.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.